our friend, Andy McCarthy, who is, I mean, this is his wheelhouse. You know him. He's a best-selling author. He's a contributing editor at NRO, also Fox News, former chief assistant U.S. attorney. He knows this Southern District of Manhattan very well. And his book, of course, Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. You may have to write another one on this, Andy. So good to have you. Thank you so much for giving us some of your time today. So this is what, because you had some amazing, I want to get to a couple of the amazing pieces that you had, particularly one about the 34 charges. Clear this up for us, because this is I know enough about the case, but I know what I know and I know what I don't. I don't understand, and I think a lot of people listening don't understand, Andy, how you can have an expired misdemeanor be used as sort of the launch pad to make this a felony charge. Of course, then at the same time, I don't know how you can just basically craft federal election law into being a state case. But I mean, wouldn't the expiration of the misdemeanor charge, doesn't that come in? Can't that be considered by the judge? It's also weird to me.
It's the weirdest thing of all time, Dana. I think you're not the only one who doesn't get it. I think that the courts of New York, if this isn't a rigged situation, and I don't want to prejudge how the judge is going to preside over it, those are the very questions that ought to be asked. But let me just lay out as simply as I can what the mechanics of how he's trying to do this are and why I think it's illegal. As you point out, the misdemeanor charge of falsifying business records has a 2-year statute of limitations. And for our purposes, let's assume that the record keeping relates to the payments that were made to Michael Cohen by Trump to reimburse Cohen's laying out $130,000 for this hush money arrangement with Stormy Daniels. And we understand that there's a second arrangement with another woman that may be relevant to this case. That happened around the same time, so it shouldn't change our statute of limitations analysis, right? So if we figure that the last payment to Cohen is December 5th of 2017, if you figure that the records of one business year generate tax records in the next year, because that's when you do your taxes for the preceding year, let's say this could go into the middle of 2018 as the end of when the statute of limitations gets triggered. I would think that for purposes of the misdemeanor, this would have been time barred in 2020. And what he's trying to do is get it into 2023. He needs a 5-year statute of limitations to do that. That's the felony charge. So in New York, the misdemeanor is the 2-year statute of limitations, but there is also a felony falsification of business records that has a 5-year statute of limitations and a potential 4-year prison sentence, by the way. The misdemeanor is less than a year. So here's what he has to prove to get to get into that 5-year felony territory, right? You have to prove that the misdemeanor was committed. That is, that he falsified business records with a fraudulent intent. That's the misdemeanor. Mm-hmm. And to get a felony, the extra element is that in committing the falsifications of records, he was trying to conceal another crime. So you have to prove that there was another crime, that he knew he had committed the other crime, and that he intentionally tried to conceal the crime very consciously by falsifying the business records. Right. So that's what you would have to show. Now, the reason I think he will not get away with this or should not get away with this, there are many reasons for it, but I think the first and to me the most obvious is in the New York statute where it says conceal another crime in the felony part. They're obviously talking about a New York crime. This is the New York Penal Code. So when you say another crime, what the statute is talking about is another New York crime. It doesn't say anything in that statute that gives him authority to prosecute a federal crime. And if the New York legislature wanted to try to give him that authority, and it's dubious whether they could have, they would have said so in the statute. Since they didn't, he's got to take the position that where that statute says another crime, it could be any crime, not just a New York crime. So I'm going to ask is a crime against the law of France okay?
Right.
You know, is a Sharia crime okay? You know, where do we
Where's,
go?
yeah.
So I think the only sensible way to read that is that it's got to be a New York crime. And since this is a criminal case, people should understand that in the criminal law, where there's any ambiguity in a statute, that's supposed to be construed in the favor of the defendant because the defendant is presumed innocent. So the defendant gets bounces of the ball.
Right.
So I don't think he will get away with this. And then obviously the other thing with this, I think he's got enormous proof problems with this, because even if this was a legitimate way to charge Trump, if we look back at the John Edwards case, which we talked about a lot with in connection with campaign finance, do you know in the John Edwards case, the Justice Department and the Federal Election Commission disagreed about whether it was a crime?
Oh,
the FEC said, yeah, the FEC said they looked at it and they said nothing here. The Justice Department looked at it and said, we're prosecuting. And then the judge wasn't sure whether it was a crime or not. The judge decided to let it go to the jury. So implicitly, the judge was finding that, yeah, maybe it's a crime. And the jury acquitted. So nobody could agree on that one, right? Which should tell people this is a very abstruse area of the law, even for people who practice, you know, criminal and regulatory law. So the thought that Donald Trump knew that he was committing a campaign finance crime on facts that are even more sketchy than the facts in Edwards's case, and that he not only knew that, but that was the reason he falsified the business records, to me is ridiculous. I mean, the thought that he even knew, because I don't think it was a campaign finance crime. And, you know, I actually went to law school.
Right.
And even showed up for class occasionally. So I just don't think, you know, the idea that, you know, this is a criminal case. He's got to prove beyond a reasonable doubt that Trump knew this was a campaign finance crime and that this was the reason he was acting, when I think it seems pretty clear that he was acting in order to, for the same reason he entered into the non-disclosure agreement in the first place, which was to keep from his wife the fact that he's paying off a porn star.
Exactly. We're talking with our friend Andy McCarthy. Andy, I want to ask you as well, because you had a great piece where you were looking at the 34 counts. It's titled, "What to Make of the 34 Counts Against Trump, That Bragg Just Needs One." And you write that Bragg looked at exactly the same evidence as the feds did, but yet he was the one who decided, yeah, it's worth 34 criminal counts, not 1 or 2, but 34. And you called it, and you had a secondary piece on this notorious prosecutorial abuse. And I love this point: the effort to camouflage with quantity what a criminal case lacks in quality. But he just needs 1 of the 34.
Yeah, so I think the best way to look at him, Dana, and this is Bragg, is we should stop thinking of him as a law enforcement official or a district attorney and take him for what he is, which is an elected progressive Democrat who won office, regardless of what office it was, in Manhattan by promising his blue constituency that he would exploit his power to get Trump. This is not like the federal government where the prosecutors are appointed rather than elected. This is not this is a political thing. It's totally infused with politics. In the federal system, when they pick a prosecutor, they vet the prosecutor in the Senate first. He's got to get, consent from the Senate before they can serve. And one of the things the senators always make a point of testing you on is whether you're going to use your power in a partisan way. That's not how it works at the state level, and certainly not in New York. This is an elected progressive Democrat.
Right. Oh, goodness.
The Justice Department has, in federal prosecutions, guidance, which in these columns that you were good enough to mention, I excerpt the Justice Department guidance on this. Basically, DOJ tells prosecutors, don't bring more than 15 counts, because what they're afraid of is you have no case, but you slice and dice what you have to stack up a bunch of counts. And the way you do that is, Dana, if you and I thought we're gonna conspire to sell some stolen property, right? Mm-hmm. And I show it to you to say, what do you think we could get out of this? And you hand it back to me and I hand it back to you. Every time we hand it back and forth, that's another felony. It's another transfer of stolen property. So there's only two of us and there's only one scheme. But every time we go back and forth, theoretically, technically, you could charge that as a separate crime. So what I assume that Bragg is doing here is, like, there's 12 checks to Cohen, and he had to put in 12 invoices, and they probably made 12 entries in the business record. So they're taking something that's one scheme and turning it into like 8 zillion counts.
Wow.
And I look back at this, when I prosecuted the blind shake back in the 90s, I think I brought 5 counts against a mass murdering multiple,
5 compared to 34 now. Oh my gosh.
Well, because if you have a murder or a terrorist conspiracy or an actual crime, you don't need to bring 47 counts. One will do. 2 or 3, you'll get all of the sentencing exposure that you need to neutralize a person like that, which is what the objective is supposed to be in law enforcement. So what you don't want prosecutors to do is, when they have pretty much nothing, suggest to the jury that this must be a really bad guy if the state would bring 34 charges against him.
Right.
And what often happens in these cases is, you'll get jurors who think they should apply the law, which is what they're sworn to do, and they don't think there's a case. And then you may get some jurors who either hate Trump or they're going to hear some very unsavory information. This may not be crimes, but this is bad stuff that they're going to hear about, right? So they'll want to convict. And the judge, if they look like they're going to hang, the judge will tell them, look, this is a charge the judge always gives in that situation. Look, you have to try to resolve this, because if you guys don't resolve it, then we'll just have to have another trial.
Oh my gosh. We can't, can't do that. We have a couple of minutes left. Our friend Andy McCarthy, I have 2 quick questions for you.
Yeah, sure.
This reports that I'm hearing of a gag order, that's weird. I don't know if I necessarily think that seems a little over the top. I just don't see the judge doing that. Do you?
I think it's possible that he could gag the lawyers, although I don't think he should. I don't see what authority he has to gag Trump. Now, the judge could gag the lawyers because they're members of the bar and members of the court. But the litigants, the parties are not. Well, the state obviously, but that would be a terrible intrusion on electoral politics for court to do that, and I'd be surprised if he doesn't.
I would as well. And last question for you, our friend Andy McCarthy, and again, I don't know the process, particularly when it gets to this level. Is there a possibility that this could be dismissed, this case?
I think so. I think it'll be dismissed if it's not a rigged process. I don't want to prejudge the judge. We'll have to see how he performs. But I think this case should be thrown out on legal grounds. I don't think Bragg has jurisdiction to enforce federal law. I think the statute of limitations has run on the misdemeanor. It may have run on the felony. So I think there's a variety of reasons why this could be thrown out prior to trial.
There you go. Our friend Andy McCarthy, get his book, Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Seems like he's going to have a part 2 of this now. Andy, always so appreciate your insights. Thank you so much for your time. We really do appreciate it.
Thank you, Dana.
Of course. Thank you.